The Galleria of Jewelry, their parent company Sterling Jewelers, well, they're on the hot seat after hundreds of employees say that they presided over a toxic work environment.
Yeah, big allegations. Craig Ashton of Ashton & Price joining us this morning to talk about this huge case. And I mean, it has grown tremendously. So give the folks at home a little background story first.
So basically you have Signet, which is a parent company in Bermuda, which is a nice island to retire to. It also has great tax benefits if you're a corporation. So they're the parent company for Kay Jewelers, the Galleria of Jewelry, and then Sterling Jewelers. So you essentially have an allegation of a hostile work environment and sexual harassment. So a hostile work environment would be, in a gender capacity, would be women aren't as smart as men, women aren't as capable as men. Sexual harassment would be the actual, what color's your underwear, I want to kiss you, that type of thing. So the issue in these cases is whether or not management is involved. So there's 69,000 former employees and current employees that are potentially members of a class. And so the allegations are that they had annual meetings where they had managers and they would have basically go out and try to find employees to have sex with the managers. There's allegations that they indicated quid pro quo. If you sleep with me, you'll get promoted. If you don't sleep with me, you'll get fired. And you won't be disciplined if you sleep with me. And then the issue, which is a really big one, Mark Light is a CEO. And so when you have the CEO, which is clearly the highest management position in the company, at a manager's meeting and they have these pool parties with half-naked and naked employees and he's participating, then you find yourself pretty exposed to a sexual harassment claim.
All right, now, so those are the allegations.
Those are allegations, exactly.
Now, how do I see it as like about 250 employees roughly thereabouts in this class action suit.
Right.
How do they go about proving any of this?
So this is the interesting thing. So there's an arbitration clause that they all sign. So if you remember what happened with DirecTV recently, where they didn't carry NBC for a while, and it was during the playoffs.
Yes,
and so you have a contract with DirecTV, but you have an arbitration clause which says that you can't sue DirecTV in a class, only individually. So you might have a $300 cause of action, but a lawyer's not going to get involved, and you're probably not going to waste your time getting it. But if you have 1 million people involved, which was Sacramento, Stockton, Orlando, Milwaukee, $300 times 1 million is 300 million. But you're limited to individual claims under that arbitration clause. In this case, a judge determined that the employees can be members of a class. So they'll have a representative group, maybe 15, that will prove to the arbitrator that sexual harassment did occur. Then everybody can becomes members of the class if they can prove by checking the boxes that they were victims of sexual harassment. So that's a big difference.
Right.
And that's what are we looking at if this does end up, if a judge does side with the class, what could happen to the parent company?
Well, I mean, there's lots of liability involved. I mean, you get back pay, you could get punitive damages. I mean, the thing that really exposes them, which is very unique, is that you have the allegation that the CEO is participating. If it's a coworker, it's harder to prove because maybe they're not imputing that behavior. It's under the worker's manual to harass somebody. If it's a coworker, you don't have that supervisory role. But when you have the CEO and then all the managers being alleged to act this way, then it creates lots of liability for them. So essentially what you want to do if this happens to you is make sure you take notes, the time, the place, especially if somebody says to you, if you sleep with me, I'll promote you.
Detailed notes.
Yeah, detailed. If you have witnesses, make sure you note those. Keep the notes in a safe place. Don't use the company computer because it's the company's computer because they can take that from you. Yeah. Don't tape record the conversation. You'll be in violation of Penal Code 362. California is a two-party state. Donald Sterling, if you remember when he was with the Clippers, they tape recorded, Vistiviano tape recorded his conversation, which was illegal, but he still ended up, even though he was incompetent, selling the team for $1 billion. So, so the point is that you want to make sure you do that and then report it to your supervisor. And to Kay Jewelers, every kiss begins with K. Probably not the best marketing for them. They may have to revisit that.
Yikes.
They might have to. Wow. We will continue following this story. It'll be interesting to have you back and give us some updates on that. It is a huge national case.
Thank you very much. And I think I'd retire to Phuket, Thailand.
Phuket.
Yeah.
And I like the juggler. He got out of the probable cause for DUI by juggling. So maybe we'll have a juggling class at our office. We'll teach all of our clients to juggle.
How to get out of that. There you go.
Always the creative guy. Yeah, you come here, you teach us how to juggle.
Well, yeah,
how about that?
And you said the buffer zone with Seinfeld. It's the Buffett zone.
It's the Buffett zone.
Exactly. Always good to see you, Craig. Thank you so much, man.
Craig.
Appreciate it. Thank you for all the insight. Time now is 9:20 here on this Tuesday morning.